This just basically makes it illegal to have an adulterant, which in Section 1 it says a substance not expected to be in human urine or other bodily fluids. It just makes it illegal to possess or to sell, give away, distribute, manufacture, market human or synthetic urine in this state, or transport human or synthetic urine into the state. The intent of using human or synthetic urine to defraud or cause deceitful results in a drug or alcohol screening test. That's essentially what the bill does.
Okay, good explanation. Any questions by committee members? Any questions? If not, Vice Chairman? Title sufficient do pass is the motion. All in favor say aye. Any opposed, nay?
Nay.
All right, I believe the ayes have it. The ayes have it. Thank you, Chairman. Appreciate it. All right, we're going to bump down to the last bill in your packet, Senate Bill 2598, Department of Public Safety revised licensing. And we're going to ask Chairman Branning if she would to explain it, and then I think Commissioner Tyndall is here, also may want to make some comments on the bill. Chairman Branning.
Thank you, Mr. Chairman. Senate Bill 2598 does essentially four things. The first thing that it does, it waives the residency requirement on the concealed carry permit for spouses of active military that are stationed here in Mississippi. And you can find this language on line 43 of the bill. The second thing that it does, it removes the intermediate license, the driver's license, only the procedural aspect of it, not the supervision part. That actually remains. So what would happen in this bill, there would still be an available learner's permit at age 15. And then when someone turns age 16, or if they've held the permit for 1 year, they can then apply for a driver's license, which would then require supervision for 6 months at those after hours times that are already defined by statute. It just eliminates the step of young drivers having to go into the driver's license office to obtain that physical license that details the supervision that the officers are going to continue to require of those young drivers. All of this is contained on lines 455 and 491. The third thing that the bill addresses is it requires petitions appealing forfeitures, suspensions, and denials of licenses to be served on both the Attorney General's office and DPS. This is found on lines 634 and 635. This is just a simple procedural addition to our statute. The fourth and final item of the bill, it removes the exception to license suspensions for participating in court-ordered drug testing programs. So it actually amends 631123, and you can see it's actually a deletion, but if you want to look at the language, it's line 586, where the language was actually deleted that's in our current statute that requires or allows someone in a court-ordered drug testing program to be removed, or to rather be part of this exception to the license suspension. Now, the reason this is in the bill, it's to keep us in compliance with the National Highway Safety Administration rules. So this is a federal rule that we're trying to make sure that we are in compliance with, and it keeps us in line for some of those federal grant monies that we receive. So that's an explanation of the bill. Happy to yield for any questions.
And we would like for Commissioner Tyndall, if he'll come forward. I know it's going to be maybe difficult to get to a microphone, but if you could find a free one, you can just pick it up or whatever you need to do with it. We'd love to hear your thoughts on this bill, Commissioner.
Okay, thank you. And I think Senator Branning obviously did a great job explaining it. As I've talked to most of you, when we talked about driver services, you know that we've been doing everything we can to address it. One of the problems that we recognized early on is that when young people come in and get their learner's permit, they get that when they turn 15. Then they got to come back when they're 16 and they get an intermediate license. And then they come back at 16 and a half and they get their permanent license. Then they got to come back when they're 20 when their license expires. Then they got to come back when they're 21, then they get an adult license. So we're making young people come up there 5 times in 6 years. It's creating a lot of unnecessary volume. One of the steps we felt like we could take out is the intermediate license, particularly because all the intermediate license does is it places a curfew on somebody that's driving from the age 16 to 16 and a half. And it says that they can't be out after 10 during the week and they can't be out after midnight during the weekend, which is probably a good thing, but I just don't think they need a special license to say that. So that part of the law creating the curfew will still be in effect. It'll just be in effect for the first 6 months that you have that license, instead of requiring you to, again, come up there a second time and get your new license after the intermediate license has expired. So that's the purpose for that. The part for the spouses on the military, including them on the exemption for the gun permits, that's the military personnel is already included, so this just adds their spouses, which makes a lot of sense. And then also to comply with NHTSA on the federal funding. And that's why we're taking the drug court aspect out of there, because you know, when we do the intermediate, the breathalyzer in the cars, it can't test for drugs. So they're on drug court programs, but they can't really test for drugs on the interlock system that they're placing in the car. So it doesn't comply with federal law. So that's why that's in there. And then as far as the requiring us to have service of process, in addition to the Attorney General, it's just so that we can get a jump step on responding to these petitions if they serve us right away. That way there's not that lag between when the AG's office gets it and then gets it over to us. Because unlike a complaint that you have 30 days to respond to, the time frame is shorter on these type of petitions to respond to. So that's why we're asking for it, and we appreciate y'all's support.
Mr. Chairman, we appreciate Senator Tindall presenting the bill.
We did. We always, and Judge, Senator, and Commissioner all in one. All right, questions by committee members of Senator Branding. Senator Simmons.
Thank you, Mr. Chairman. I just had a question. In Section 4 of the bill, the administrative license suspension, what is being deleted in line 512? And also, again, what is being deleted on lines 586?
I'd have to defer to council on line 512. I can't answer on 586. I can jump in and tell you. This language, what's in current statute, the words that are deleted, or participant in drug testing program. Those are the words that's removed from the current statute in 586. But again, I'd like to defer to council on your question on line 512, please.
All right, we'll have to get Mr. Samsel to answer that one for us.
For 512, the only thing that's deleted is "and," so that they don't have to be on all of those things at once. It's just a technical amendment. And then you said 586?
Yeah, so 586, that's a substantive change. It's not technical. Correct.
That's correct.
Right.
And wasn't that language added when we actually started the non-adjudications on DUI? And wasn't that language added to this statute when we started like the non-adjudications on DUI and started allowing people to participate in a court-ordered program?
Yeah, I believe that's correct. I wasn't here during that time.
So what's the explanation again from deleting that language?
Senator, I can tell you that it's an attempt by the department to comply with federal law. So under the National Highway Safety Administration's rules, and I'd be glad to get you a copy that I don't have it with me, they just recommended that this language be cleaned up to comply with their internal rules and procedures.
But we still will allow the interlock restricted license, which was also part of the DUI law for non-adjudication.
That language stays. That's correct.
So the Fed said that language is okay, but the court-ordered program?
That's correct. I understand that there's no issue with the interlock language that's there, but it's only the court-ordered drug testing language that there was an issue.
And when we first, may I?
Certainly.
And so, just for the members of the committee to understand, when we first started or enacted the interlock, it was to allow people to get that non-adjudication, but the very next year, it became a financial issue because it was a money-making thing that we had a concern about, and certain drivers who had a first offense DUI, they were unable to afford to interlock. And so this deliberate body added court-ordered programs in, so if you were not able to afford to interlock, you still had the opportunity to be ordered by the court to participate in a court-ordered non-adjudication type program, because we still don't want the driver on the road drinking and driving, but we was also trying to give them an opportunity to have the same benefit of getting that first offense non-adjudication. And so I guess I'm concerned substantively, despite what the feds are saying, and I don't want to lose any money to the state, but what effect, if any, would it have on people's ability to still have the court-ordered non-adjudications? That's my concern.
I'm not sure. I agree with your assessment that the reason that it was provided in the statute to begin with was a cost savings of several years ago, but I think now the goal and the issue is compliance. So I don't know how to answer the rest of your question, but
And thank you for
that's
your,
the goal.
thank you, Mr. Chairman.
Thank you. All right, Senator Wiggins, Chairman Wiggins.
Thank you, Mr. Chairman. So to Senator Simmons' point, can you read that language that was deleted?
Certainly. It was, or while participating in a court-ordered drug testing program, 30 days after receipt of the court abstract.
So they're allowed to do that if what Senator Simmons said, if they, they're allowed to suspend their conviction if they go through that court-ordered program. That's what was there.
Correct.
Okay. I would agree with what Senator Simmons is saying, and to the point about the feds, let me just, I think Senator Simmons knows what I'm talking about. With all due respect to the commissioner, the feds come in with the long arm of the federal government and try to force us to do stuff that's against the interests of our citizens of Mississippi. What am I talking about? I'm talking about non-adjudication on commercial drivers in particular that this committee has had bills on in the past. And the feds come in here and they tell us what we're going to do. And to my conservative friends, if we're conservatives, we have a distrust of the federal government telling us what to do. And so and this isn't any disrespect to Senator Branning, because I think she's doing, and I know this happens, about what the feds do, and I think they come in and they say, well, this is to comply with federal law. And then they hold highway funds against us if we don't do it. In my world, that's called extortion. So we're either going to do what's right for our citizens, and I think that what we've done with our citizens on the non-adjudication of DUI has worked. This legislature has spent 4 or 5 years working on the DUI bill, and I think it's gotten to a point where it benefits our citizens in the criminal justice system that we're working on. And so I say all that to say that, Mr. Chairman, I have an amendment, and that was my speech on my amendment at the proper time.
Thank you
on that.
Thank you for being concise. We appreciate that.
And I second the amendment.
Okay. Well, let's let you offer your amendment, and then we'll ask if Senator Branning would like to respond to that amendment. Senator Wiggins, if
Thank
you'll
you.
make it.
My amendment is to replace or put back the language that was deleted in line 586.
Okay. And Senator Branning, would you like to respond?
I wish I had the information that talked about what it means if we remain in non-compliance with the statute. And I don't have that in dollar figures, but
Well, I'll respond to that. I don't know the numbers, but I can tell you this, that it's a threat, and they come in and they say this to these commercial drivers, and I know this isn't what this bill is about, but they come in and you got 18-year-old kids who are commercial drivers who are not able to get non-adjudication, who are feeding their families. And the feds are coming in telling us we're going to hold your highway funds. So we're either about Mississippi and federalism, or we're about giving in to the feds when they extort money from us. And I know because I've heard that too when I was in Chairman Fillingane's position. I heard that. And the bills that Senator Simmons and I and others have pushed forward, it's amazing how the feds would come out and they'd start making threats against senators that we're going to take your highway funds. So, but you know what? I haven't seen anything where they've actually done that.
Okay. Other comments, questions? All right, you've heard the amendment. Any questions of the author of the amendment? If not, all in favor of the amendment, say aye. Aye. Any opposed, nay? The ayes have it. All right. Now, any other questions for the author of the bill or of Commissioner Tyndall, if I could extend that courtesy to the committee? Anybody else? All right. If not, Chairman Wiggins for a motion.
Title sufficient, do pass, committee substitute.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay? The ayes have it. Thank you all. Thanks, Chairman Brandon. We appreciate you. All right. If you'll go up one bill from the bottom of the packets, it's Senate Bill 2578. Chairman Blackwell, this is his bill. I think there's a technical amendment after he explains it that the council has advised me of, but if you'll explain 2578, Chairman Blackwell first.
All right. Thank you, Mr. Chairman. Currently, current law allows for an electronic signature to obtain an arrest warrant. What this bill will do is to also extend that to a search warrant. I think speaking to a room full of attorneys, so you guys know better than I how the process works, but it's kind of unfortunate that somebody can have an electronic signature to arrest somebody, to put them away, but at the same time, in order to do a search warrant, you're going to have an officer track down the judge, get his signature. In many cases, if this is something out in the field like a DUI, you're going to have, and they want a blood sample, one officer is going to have to stay with the, I don't know if you say defendant or the accused, and the other officer is going to have to track down the judge to get a signature. So you're basically taking resources out of the field. But anyway, this is done federally. It's also done in a large number of other states. So that's an explanation. I'll be happy to answer questions.
Thank you, sir. Questions of the author of the bill? Any questions? If not, Vice Chairman?
I suspicion do pass.
You've heard the motion. All in favor say aye.
Aye.
Any opposed say nay. Okay. The ayes have it. Thank you, Chairman Blackwell. And I failed to mention, which I think I was supposed to, this is being Zoomed. I think Senator McDaniel is maybe joining us via Zoom. I'm not sure if there are any others, Ms. Trowles. If Senator McDaniel, if you have any comments or questions, feel free to text me or call in and we'll try to accommodate you. All right, Senator McMahon, Chairman McMahon, has a bill, Senate Bill 2283. If you'll come forward and grab a microphone, Senator McMahon, we'll recognize you to explain your bill.
Thank you, Mr. Chairman, members of the committee. This is not a lengthy bill, but the police chief in the city of Tupelo asked me to draft something for him. Currently, if you block a roadway in the state, whether it be a county or state or a city roadway, it's just a misdemeanor with a very minimal fine. I think the maximum fine is $300, but there are some cases where we think that should be enhanced, and that's what this bill addresses. That I think, you know, the right to assembly and the right to protest is a First Amendment right, but I think equally freedom of the roadway for those to travel is also equally important. And so what this bill would do is if you're not properly permitted and you maliciously block a roadway, that fine would be $1,500 and a year in jail or both. And then on the second offense, it would be a $500 fine and imprisoned in county jail for 25 days. And basically all of the action is in Section 2, and I'll be happy to take any questions.
Okay. Senator Turner Ford.
Thank you, Mr. Chairman.
I should say Chairman Turner Ford. I'm sorry.
Oh, no, that's fine. Senator McMahon, is this bill, has it been filed in response to a specific incident?
There have been some cases that this would have been applied if it had existed.
Can you explain?
Well, currently, let's say in one of the cities you represent, let's say there was a malicious protest blocking the roadway, and law enforcement shows up. Really, the only thing at their disposal, as far as a tool, is my understanding, is jaywalking or obstruction of road, and it carries a minimal fine. In some cases, as small as $25. I think the maximum fine is around $300, and that could vary. Okay, that could vary from jurisdiction to jurisdiction, but that's the highest that I've heard of is about $300. Did I answer your question?
Not really.
Well, let's use the instance that happened 3 weeks ago out here on the 4-lane. Someone blocked the road for a period, and law enforcement law enforcement did not even show that night, is my understanding, but they know who some of those people are, and now they could use this type of legislation to give them an enhanced penalty for blocking the roadway.
Thank you.
Yes, ma'am.
Senator Barnett, so Chairman Barnett.
Thank you, Mr. Chairman. My question goes back to the question that Senator Chairman Angela Turner Ford asked, and that was, is there any specifics since the Tupelo Chief of Police asked you to file this? Is there anything in Tupelo that would cause him to ask this question? Then my second one is that when we talk about the incident that happened in Jackson, I'm sure that there should have been someone from Jackson or some of these other places that maybe would have signed off on it and agreed to it. And the fact that you mentioned protesting and police showing up, before you said that for other individuals using the roadway. So what happens if there's an incident where there's a block party or individuals in a neighborhood decide that as a neighborhood they just want to get together and do a barbecue and don't feel that it's a permitting situation, or would they be in violation as well?
Senator Barnett, thank you for your questions. First of all, I'd like to say that Tupelo is a 5-time All-American city, and everyone is welcome in Tupelo, Mississippi. And we've had several permitted protests in Tupelo in the last 4 years. We have. They're properly permitted, the roads are properly blocked off for the safety of the protesters, and we want people's First Amendment rights to be practiced in the city of Tupelo and in the county of Lee County, Mississippi. It's important to me that people's First Amendment rights are heard. But equally important to me is that people know that they can freely travel on the roadways in this state without being obstructed. There were some cases in Tupelo where some individuals who left the protest and tried to block roads, and they were asked and they did move. That's not what this is. This is for those that maliciously block roadways and will not clear the roadway. To help law enforcement make those a proper arrests, issue fines, and clear the roadway. The second issue about the block party, I think that's a valid point. Normally, I used to sit on a municipality, as you used to be a mayor. I used to be an alderman. You used to be a mayor. If you're going to block the roadway in a neighborhood, you're supposed to apply for a permit. That goes for even in most cities and municipalities now. You have to have a permit even for a garage sale. And I don't think it's an undue burden to apply for a permit. And in some municipalities, though, they don't even charge for the permit for a block party or to block the roadways. It's about being mutually respectful of each other's position, Senator. I hope I adequately answered your questions.
Senator Barnett, did you have any follow-up? No follow-up. Okay, and I've got a long list, and I'm going to get to everybody. Senator Hill, if you would, I think you sought recognition.
I was just going to comment that the word maliciously is in the language, and a block party is not typically malicious. So that was it.
Thank you, Chairman. All right, Chairman England.
Yes, thank you, Mr. Chairman. Thank you, Senator McMahon. I have a question. Just looking at this, and I understand your intent, and by no means do I disagree with the intent you have here, but I'm worried about unintended consequences this may have in the fact that the phrase maliciously obstructs the free, convenient, and normal use of any public street. I feel like there's maybe some definitions and some more language that may be needed so that unintended consequences don't come about from this bill. For example, we don't allow sheriffs in Mississippi, to my knowledge, to have radar in their vehicles. I have people that I know and constituents that I represent in counties that live on roadways where their children will play and ride their bikes on the streets, and these fathers, I know one very well, will occasionally put orange cones in the roadway to require drivers to either slow down or go through the cones while their children are playing. Again, the maybe an easier solution if the sheriffs could come by with they have radars in their car. We don't do that here in Mississippi. So by reading this, if that father is protesting speeders in his neighborhood by putting out orange cones, we are now increasing the penalty that father would be liable for, just for trying to protect his family. Am I wrong in that, or do you think that maybe we could? And I'm willing to work with you to try to maybe clear up the intent there, but I don't like us passing bills that maybe will lead to unintended consequences.
Senator England, every piece of legislation we pass has unintended consequences.
That's right.
Okay, now, I can appreciate what you're asking. I really can. First of all, I will say that I know there's one county, there may be more than one county in this state that is authorized to run radar.
Okay.
So that is a fact. But as far as your question, look, municipalities are governed by boards of aldermen. They're elected. The mayors are elected. They're appointed. They appoint their own prosecutors. They appoint their own judges. I trust the municipalities in this state to make the right decisions. And I think your question is misleading, Senator, because we all know what we're talking about here. We're talking about the freedom of commerce, that to travel freely. And I'm not necessarily in a neighborhood. I'm talking about freedom of the roadways where you're traveling on a county road or a highway or an interstate. And I would entertain, adding interstate to this language because it's not in here. But that is what we're talking about. We're not talking about block parties. We're not talking about men or women who might sell vegetables on a county square. That's not what we're talking about. And most people in this room understand that. But I do appreciate your question, but that doesn't address the spirit of this. And I don't think that the law is going to be misapplied by law enforcement and prosecutors and a judge. There are multiple layers that will have to vet this type of situation.
Chairman England?
Yes, Senator McMahon, if I can just rephrase my question, because if it was misleading, that's on my fault. That is my fault for maybe asking a misleading question. So let me just ask it more clearly. If a neighbor calls the police on an individual for placing orange cones in their roadway for the intended purpose for protesting speeders in their neighborhood, and those police arrive at the house and arrest the person for putting the orange cones, can that person then be charged under the Freedom of Roadway Act?
I would not think this law would apply, but that would be up to the arresting officer and to the prosecutor, and ultimately to a judge.
So it may possibly apply then?
I suppose it could happen, but that happens every day anyway. People are arrested false pretenses anyway.
I understand that. Well, thank you for answering my question, Senator
Yes,
McMahon.
sir. Thank you.
With the way it's written, I just can't support it at this time. Thank you.
Okay, thank you, Senator England. What counties do you represent and cities do you represent?
Yes, Jackson County. My sheriff is Mike Ezel. He'll be up here. Have a representative up here this afternoon.
Great.
We'll meet with him. Thank you.
Perfect. Maybe we can exempt your county from this.
All right, Chairman Wiggins.
Well, I represent Jackson County too, and I'm fine with it. But my question goes to what Senator Hill and somebody else reached out. So I don't want to be, you're not a lawyer. I'm going to put on my criminal law hat here for a minute. The maliciously that Senator Hill brought up and asked me, and my question is going to be, is this what you mean intended to it? But maliciously is what we call a term of art in the criminal law. That with that being in there, there has to be criminal intent. And what you're saying is there has to be criminal intent to do this.
That's the spirit of this legislation.
Okay. If it didn't have it, then if you just sat there and did it, then you could be charged. But maliciously, under Supreme Court and criminal law, that's a term of art that says you have to have criminal intent. And before you can be charged with probable cause and before you can be convicted, you have to have that, and that's what that maliciously means. And also, you put in unpermitted in there, right?
That's correct, Senator.
My guess is that's for a reason because that's only if there's no permit. Your First Amendment rights are supported, and the Supreme Court has said that you can put time, place, and manner regulations on First Amendment. And so what this is only limiting it to is if somebody doesn't get a permit. Is that right?
That's correct, Senator.
So if you want to stand out in the street and you want to do that, then you're welcome to go get a permit. let the authorities know so that we can all be safe. Is that where you were going with that?
That's correct, Senator.
Okay, and then in section 3, it also specifically states that people's First Amendment rights are to be honored. So I think that's clear. That's where you were going with it too.
That's correct.
All right,
I respect the right to protest. I want Mississippians to protest. I just think Mississippians should respect each other, and we should be properly permitted if you're going to have a protest and block a roadway. That's what it's about. Senator Simmons, his brother, his very handsome brother, as a matter of fact. For those that don't know, they're twins, but his brother is a little better looking than him. But his brother is a mayor. And if you travel through his city, you would expect to be able to take the highway straight through his city without being stopped for unlicensed or unpermitted protests. That's all it means, and you could fill in the blank with any city.
It's for respect and law. With that, that's so that you can exercise your First Amendment rights, but also respect law and order and safety for the citizens and actually the participants as well.
That is correct, Senator.
Thank you.
Thank y'all. Senator Stuber.
Thank you, Mr. Chairman. And appreciate Mr. Senator McMahon on this bill. I do support the bill. I had a few questions in section 2. You've got fined up to $1,500 or imprisonment for a term of not exceeding a year. But then the next sentence is a minimum of $500 and 25 days in jail. Is that correct?
That's correct.
Do you think I feel like we could give a little more discretion to the Justice Court judges and municipal court judges. If we're setting a maximum of $1,500 and a term of a year, I mean, it could leave it up to the judge to make that decision.
I think that still maintains the spirit of this legislation, and if you want to, what are you recommending? Eliminate the bottom.
And I don't know how the committee would feel, but I think just we could eliminate that last sentence from the end of line 11 to line 14 and just say a maximum fine of $1,500 or imprisonment up to a year or both. And then I think the judge can sentence them from no time to, a year in jail. I don't know. I feel like we're just putting it.
Is that an amendment you'd like to offer, Senator Stuber?
Well, I mean, I'd be open to some discussion about that.
Okay.
But
Senator Hill.
I just wanted to make the point that, we've had discretion in a lot of laws, and we see that people have not typically been punished up to the maximum in a lot of the laws that we have on the books. And I think that, with what we saw on the interstate in Jackson and highway, I checked the definitions. Highway typically does include interstate in most of our laws, the way I understand it. But I think that when the Jackson police chief did his live stream and stuff after the incident where the road was blocked for so long in Jackson and he was looking at videos, I think that he truly wants to never let that happen again. And I think that if we say, if you're going to maliciously get out there and block an interstate highway, you're going to spend 25 days in jail. I don't think that's too much to ask for interstate commerce in the state of Mississippi, so that people that want to do business in Mississippi understand that they're going to be able to free flow and bring their goods and services through the state of Mississippi, and that we have some teeth in the law to make them not have to sit, on the highway for an hour or whenever that's blocked. And I just think that putting some teeth into this, as much as this has blossomed all over the country, would be a prudent step for someone with the job of the Jackson police chief and other people who have major thoroughfares going through their city.
Senator Stuber?
I don't disagree with Senator Hill's comments, and I think in that incident, I think they probably deserved more than 25 days in jail. Probably should have been in jail for 6 months or so. I just feel like we were putting a small window, and then you get, in reference to something Senator England said, which I don't see that likely, but you're going to have the guy in the neighborhood going to jail for 25 days. Like I said, I don't think it's likely, but you're limiting the court's ability to preside over a case. I mean, you're going from $500 to $1,500 and 25 days to a year. We've got some felonies that you don't have any jail time. I mean, it can be offered by the, or ordered by the judge, but a lot of times it's not. It'd be hard for me to support the bill as it's written, but I do support the bill as a whole.
Okay.
Thank you, Mr. Chairman.
Thank you. Senator Barnett, you sought recognition next. Chairman Barnett, I'm sorry.
Thank you, Mr. Chairman. My question for Senator McMahon again is that you keep referring to the incident that happened in Jackson. Senator Hill is referring to commerce being moved throughout the state. With that being said, both of the thoroughfares that you all are talking about is interstate travel or highways. But you keep talking about in this bill if there's an individual in a neighborhood or on a county road. So are we saying all roads in Mississippi, or are we talking about interstates? I think that's a federally road that I don't think we really have any jurisdiction on as to how people handle it. I think that should be a federal level. But if we're going to talk about major places, then can't we say that instead of county roads? And because there are some individuals, like Senator England said a minute ago, that may decide they want to do something on a long county road, and there's hardly any traffic, but you got a neighbor there that may not like the fact that they're doing this and call in the authorities, and now you have something that we shouldn't have. I think sometimes we push our legislation a little too far to in my opinion, I think we're taking away more freedoms from everyday Americans than we are giving here at this Capitol. And I think this is one way that we are stripping some of the freedoms of individuals who live in places where there's already an understood agreement amongst them that they do things like this. And to always find ourselves wanting to have a permit for everything that we do, to me, goes against every conservative thing that I've heard here at the Capitol. But if we want to talk about the incident in Jackson on the Interstate 20, I can agree with that. If we're talking about a main street through town where there's a great deal of traffic for businesses every day, I can agree with that. But pushing it to every road and street in the state of Mississippi, I just cannot support this bill like that. Thank you.
Senator McMahon, would you like to respond?
Sure. Senator Barnett, thank you for your comments. On line 8, it addresses your concerns, any public street, highway, or road during an unpermitted protest. And secondly, as far as enforcement of speed law on federal highways, Mississippi State Troopers enforce speed limits every day on federal highways, including the Natchez Trace. I believe the commissioner would also, that we don't have federal troopers in this state writing traffic tickets on interstates. But as far as you're a former mayor of Heidelberg, correct? So let's say that me and my family are coming through your city, and we come through and y'all are having a block party. More than likely, you're going to have a detour, or you're going to have a traffic officer there says, hey, we're having an event down here, a festival, or people have gotten together and they're doing a barbecue. Hey, you just need to go around this way. Would that not happen? Okay. That's
someone that's off of Main Street. That's what this bill also speaks to. We're not talking about that. We understand that.
Okay. Senator Thompson.
Thank you, Mr. Chairman. I just had a comment. I wanted to support what I think is a forthcoming amendment from Senator Suber on either eliminate or deleting that minimum. My concern with having that minimum in this bill is that if a DA is presented with a minor traffic infraction, that somehow he could use this language to shoehorn what would be a misdemeanor, maybe just a traffic fine, or even a movement violation, to lock a guy up for 25 days. And that, I wouldn't want to see that happen. So with that language in there as it is, with that minimum language in there as it is, I can't support the bill, but I think there may be an amendment forthcoming.
All right, let's go to Senator Suber. I do think he sought recognition again and may address some of these questions.
Thank you, Mr. Chairman. I'm gonna throw something out there and see what the committee thinks.
Sure. State your amendment.
I would like to leave the language up to line 11 and make that a first offense. And then on a second offense, maximum of, $2,500 and/or a year in prison or a year in county jail, with the minimum of 30 days in jail for a second offense.
All right, restate that one more time, if you would, for our council.
I would like to leave the language up through line 11 make that a first offense for $1,500 or imprisonment of a term not exceeding a year in the county jail or both. And then if there's a second offense under this statute,
So you would delete the last
I would delete
sentence?
the last sentence
Okay.
in section 2. And then we can make a second offense, we can make it section 2 or just, or section 3, I'm sorry, or add a subsection of section 2. Make a second offense of $2,500 maximum sentence or 1 year in the county jail or both, with a minimum of 30 days in jail. And I would offer that as an amendment.
All right, questions for the author of the amendment? You've heard the amendments. All right, all in favor of the amendment, say aye. Aye. Any opposed, no?
No.
I think the ayes have it. Let's try it again, one more time. If you're in favor of the super amendment, say aye.
Aye.
If you're opposed to the super amendment, say nay.
No.
All right, division has been requested. Let's hold your hands up. And if Senator McDaniel is listening in and would like to participate, he can text me, or I don't know if we can hear him on the Zoom or not. But let's show a show of hands. If you're in favor of the amendment, please raise your hand, and our Secretary, Senator Thompson, will give us a count. 7. If you're opposed, please raise your hand high. 1, 2, 3. Okay, the amendment passes. All right, so now, any further questions? I don't want to miss anybody. I was trying to keep a list as we went. Senator Turner Ford.
I was trying not to ask my
That's
question.
okay. Ask.
Thank you, Mr. Chairman. Isn't it currently illegal to block a public highway under one statute, and then it's also illegal to block a road that's been adopted or added to the county register under another?
I believe that is correct, Senator Turner Ford.
And so really what we're getting at here is criminalizing people who gather without a permit.
Would you like to address that, Senator McMahon?
Currently, it's my understanding those fines are only around $300, and it's a misdemeanor. That's my understanding, Senator. I can understand. I think I can understand some of your concerns, but I think there's a real understanding and a commitment in this bill to understand that the roadways in Mississippi, you have a right to travel that roadway, and it should not be obstructed by malicious acts. And that's the nature and intent of this bill. But being an attorney, I could see how, you're thinking about, somebody blocks a road in a neighborhood or something of that nature. But that's not what this bill is really addressing.
I think what I'm concerned about most is, let's just say, the streets around here.
Yes, ma'am.
And, people decide that they want to gather and protest what we're doing right behind the Capitol. They don't have a permit. And as I understand this section of the code, if that type of activity occurs, it's up to the law enforcement officer to go out and say that they have maliciously gathered. And I don't know, I don't see how that type of activity can be defended under this proposal here.
Because the fine is, in my opinion, the fine is inferior for the act. Let's say that people block the roadway out front one morning and we cannot get to work. Don't we have a right to freely travel in front of this building to come to work without being maliciously blocked?
I'm not sure under that context that I would expect someone to be fined $1,500 and sentenced to 30 days in jail.
Well, I think they'll sure think twice about it if people are going to start blocking the roads and keeping the freedom of access to the roads. Thank you, Mr. Chairman.
Thank you, Chairman. All right, any other questions? Senator Simmons.
Thank you, Mr. Chairman. I guess I'm just concerned about criminalizing potentially protective speech. I think the debate has gone on quite a bit, so I just have a motion at the appropriate time, Mr. Chairman.
Okay, any other questions or comments of the author of the bill? Seeing none, what is your motion?
I move the table, Mr. Chair.
All right, you've heard the motion. Would you like to speak to that motion?
I think that we're just getting into, yes, Mr. Chair.
Yes.
Senators, I just think we're getting into the business of potentially criminalizing potentially protective speech. During the discussion and the question and answering of the bill, it seems like there are already statutes on the books to address some, if not all, of what the concern is. And I don't know if it's appropriate to just look at those statutes and try to increase the fine if that's the concern. The fines are too low in the existing statutes. But to come up with a new statute in the code that specifically speaks to protests, that is very, very, very concerning to me regarding our First Amendment constitutional rights. And so I really appreciate Senator McMahon and his comments about my illustrious twin brother. But he certainly in the city of Greenville would not allow his police department to stop people from exercising their First Amendment rights. So that's an explanation of my motion, and I hope I can get your support.
All right, Senator McMahon, would you like to respond?
Since you used the example, Senator Simmons, so let's say I'm traveling in an RV or in my personal vehicle and I come through Greenville and the highway's blocked. So the right of the people to protest without being properly permitted to block the interstate trumps my right to freely travel on the road. Is that what you're saying?
Senator McMahon, I'm not saying that. I just think that.
But that's exactly what you're doing.
No, I believe that your law enforcement should be able to deal with that in a very peaceful and civil way. I know if you have that 5-star city that you mentioned, your mayor and all your elected officials, whether it's the municipality or the county, will deal with that. And I know in my areas, they certainly will deal with that in a very civil and respectful way. And you'll be able to actually continue to drive on the road. And so that's the way I see it. And I hope you will support my motion.
Okay, you've heard the motion. All in favor of the motion, please raise your hand. All right, Secretary. All right, if you're opposed to the motion to table, please raise your hand. And what is the vote count? 5 and 5. All right, I'm going to vote against tabling. All right, so the bill is not tabled. Are there any other questions at this time? All right, for a motion. Committee substitute, you've heard the motion. All in favor say aye. Aye. Any opposed, nay? Nay. All right, let's have a show of hands. If you're in favor of the bill, please raise your hand high so we can get a count of that one. 5, and if you're opposed to the bill, please raise your hand.
6.
All right, the bill fails. All right, thank you all for that really good discussion. I appreciate Senator McMahon, you coming.
Mr. Chairman, thank you so much.
Thank you for your time.
Committee members.
Mr. Chairman?
Yes, sir.
I enter a motion to reconsider on that bill.
All right. You have noted, is that what you
That was what I was trying to do.
All right, there's been a motion to reconsider entered. All right, thank you.
Thank you, Mr.
I know
Chairman. Thank
the
you, members of
time-
the committee.
Yes, thank you for your time. Then the time is getting short. We have quite a few bills, and I want to apologize to my friend, Co-Chairman, Vice Chairman England. He's got a very important bill dealing with revenge porn. I really don't think in 9 minutes we're going to be able to get through all of that. So let's try.
Mr. Chairman, I'm okay with that one being short if you'd like it to be.
There is a couple of quick bills, and we do have. Okay, let's quickly, Senator Wiggins or Chairman Wiggins, if you would try to tackle the other one that Commissioner Tyndall is here on today, 2279. If you'll give us an explanation of that one, please, sir.
Thank you, Mr. Chairman. This bill was requested by Commissioner Tyndall, and in the line, it says what it says. I do have an amendment at the proper time. It makes absconding more than 6 months a separate offense, and actually, I do have a amendment at the proper time.
Go ahead and explain your amendment if you would.
Okay, so my amendment would be first to amend to name this act the Lieutenant Troy Morris Act, who a Mississippi trooper who was killed in the line of duty, and second, in the amending language to change the word probation to earned release. Commissioner Tyndall has spoken with the Department of Corrections, and the issue that brought up this bill, what has happened is members were absconding for more than 6 months. They weren't able to do it, and what we thought it was one way. What has been happening is it was when it's on earned release from MDOC. So it says parole and earned release is what my amendment would say.
So you would change the word parole.
Parole and earned release.
To earned release, okay.
Yes.
Questions, and Commissioner Tyndall, if you would like to speak to the bill?
Or, I'm sorry, parole or earned release.
Okay.
Parole, change
Thank you.
probation to earned release.
Correct.
Okay. Commissioner Tyndall?
Appreciate everybody's indulgence. I know you gotta go, but we recently released the MBI's most wanted list. And on that list, there were 3 individuals that had been on earned release supervision that had absconded from supervision for a number of years. And these were people that were convicted of sex crimes and murders and manslaughters. And so what this would do right now, if they don't report, they get picked up, then they just have to come back and finish the rest of their sentence. So there's really no penalty for them for absconding. And to me, earned release, you're basically escaping when you quit showing up and reporting to your probation officer. And the #1 guy on our list actually was acting as a preacher in North Mississippi, had gone on living his life even though he had murdered his girlfriend and left the baby outside the daycare. And so this would create a new felony so that in addition to having to complete the rest of their sentence, they could receive a new felony that could put them in jail for a longer time and give them incentive to keep showing up for their post-release. Now, Lieutenant Troy Morris with the Mississippi Valley Patrolman, murdered last summer. The individual that murdered him had absconded from parole and was also wanted for murder out of Gulfport. And so that's why we've asked that it be named after him, and his family's in support of that.
Okay, questions, Senator Simmons?
Thank you, Mr. Chairman. I guess with the amendment, now we're making it a new code section, but I guess my concern is regarding probation and parole. How will we treat those people? Because right now, when someone actually fails to report or fails to pay supervision fees, they may go back in front of the judge and may be up to go to a technical violation center or may be up for probation. And so I know in the situation that the commissioner mentioned that was an extreme situation where somebody had actually had absconded for 2 or 3 years or whatever. I'm just concerned about those probationers who may lose a job, may move, and everything we put in the law that they could actually be sent to a technical violation center or something like that. I know time running out. Like what are we doing regarding those individuals as opposed to just sending them back to prison serving a potentially 5-year sentence as opposed to dealing with them as a probation violation?
Okay, well, so the 6 months language in the bill tracks what we've done. If you recall, that the language or the law dealing with technical violation centers, we amended that and the absconding has to occur more than 6 months. And we said there was a discrepancy, and now if you abscond more than 6 months under the probation law, that is a separate violation. Okay, so which keeps you, because what was happening was they were being sent to technical violation center, and so so that was passed. Then this 6 months is tracking that. So if you're gone for a month, you can't be charged with this. Okay, and then separately you can charge them with a separate felony, and that's what the commissioner is saying, is that they have no leverage, if you will. It's similar to escape, and the escape statute. To be quite honest, actually, this is amending this statute. Is you can, and the earned release and the parole did not apply under the escape statute, so we're just trying to bring that in. So to your question, it's actually bringing it in line with what the probation parole law is, and then yes, they can be revoked and sent to the technical violation center, I believe, but they would end up having another charge if the grand jury indicted them. I mean,
last comment, I just know I've represented, and I know you have too, Senator Wiggins, people who may be a drug addict and they may very well be homeless, and they have not reported to probation or parole not because they did not want to, not because they simply, they were literally found walking the streets of Greenville, and they were actually on a property crime. It wasn't a sex crime, it wasn't a murder or a manslaughter. They literally had a grand larceny because they were serving, they were a drug addict, and we were looking for them. And there's a warrant for violation of probation, and we finally found them on a corner in Greenville, arrest them, bring them back in front of the circuit court judge, and based off this, they looking at spending 5 years in prison just because they homeless and on drugs. And that's just my concern. That's just my concern. I just want to make sure it's clear.
All right, good questions. Any other questions, comments? If not, Senator Wiggins for a motion.
Title sufficient, do pass, committee substitute.
You've heard the motion. All in favor say aye.
Aye.
Any opposed, nay?
Nay.
The ayes have it. At this point, I'm going to entertain a motion from Chairman England to recess subject to call of the chair.
Yes, I will make that motion.
All right, all in favor say aye. Aye. Any opposed, nay? All right, we'll announce when the new resuming of our meeting will take place after we check the calendar. Thank you.